Good evening, everyone. This evening of May 15, 2021, I will going to discuss the Republic Act Number 11232, entitled the Revised Corporation Code of the Philippines, Sections 12, 13, and 14. And so for our overview, there are 18 main slides for us to tackle. The first one will be the presenter or meet the presenter. The second one is the definition. The third one is the section 12, and the fourth is the section 13, and so on. For our meet the presenter, I am Jasmine Biaje from PCBET 01402A, your presenter for sections 12, 13, and 14 of this code. On this slide, we're going to define what is incorporation. An incorporation is the legal process used to form a corporate entity or company. Registering an association for legal declaration of a corporate entity. For our keyword for this incorporation will be a legal process on forming an entity. We'll go now for our first section, which is the section 12. Section 12 is the minimum capital stock not required of stock corporations. It means that the stock corporation shall not be required to have minimum capital stock except as otherwise specifically provided by special law. For our general rule will be there is no minimum authorized capital stock, and for our exception will be if provided by special law. And what is that special law nga ba that gives exception sa ating section 12 of this code? A special law is one that confers particular privilege or imposes peculiar disabilities or burdensome conditions in exercise of common right upon class of persons arbitrarily selected from general body of those who stand in precisely same relation to the subject of law. Madidiscuss yung minimum authorized capital stock or authorized capital stock sa end or before mag-end itong discussion na to, kasi sa may latter part na discussion na to, doon natin madidiscuss yung mga terms na ginamit natin on these sections. Section 13. Section 13 is the contents of the Articles of Incorporation. All corporations shall file with the Commission Articles of Incorporation in any of the official languages, duly signed and acknowledged or authenticated in such form and manner as may be allowed by the Commission, containing substantially the following matters, except as otherwise prescribed by this code or by a special law. This section talks about the requirement of any corporation to submit the Articles of Incorporation in the Commission on Articles of Incorporation. So, these are the contents of Articles of Incorporation. The first one will be the name of the corporation. In choosing the name of the corporation, it should be first easy to recall or remember. It must be understandable, so it is easily stored in the memory. Second, pleasant meaning creates pleasant feelings. It must produce positive or favorable feeling upon saying or mentioning to the public. Third, easy to pronounce. Fourth, easy to spell, and lastly, related to the product. It must describe the product or represent the features of the product. Second, or letter B, the specific purpose or purposes for which the corporation is being formed. Where a corporation has more than one stated purpose, the Articles of Incorporation shall indicate the primary purpose and the secondary purposes. provided that an non-stock corporation may not include a purpose which would change or contradict its nature, such as. So what is non-stock corporation nga ba? So non-stock corporation is basically a corporation that does not issue shares of stocks. Since it is non-stock corporation, a non-stock corporation that has no shareholders. So meaning, yung mga owner nun ng non-stock corporation ay tinatawag na members. Since discuss na siya ni Ms. Alim, di na natin siya explain further on this section. For our third or letter C, the place where the principal office of the corporation is to be located, which must be within the Philippines. 4, to letter D, the term for which the corporation is to exist if the corporation has not elected perpetual existence. And what do we mean when we say perpetual existence? Perpetual existence is a characteristic of a business corporation of having no expiration, an ending, or unlimited term of existence. Also, it is the existence of a company that is not affected by the death, retirement, insolvency, or insanity of its members. It has a separate entity from its members. So, meaning, iba siya sa partnership ang corporation according to its term. For our fifth one or letter E, the names, nationalities, and residence addresses of the incorporators. For the letter F, or for the sixth one, the number of directors which shall not be more than 15, or the number of trustees which may be more than 15. Letter G, the names, nationalities, and residence addresses of persons who shall act as directors or trustees until the first regular directors or trustees are duly elected and qualified in accordance with this code. H, if it is a stock corporation, the amount of its authorized capital stock number of shares into which it is divided, the par value of each names, nationalities, and residence addresses of the original subscribers, amount subscribed and paid by each of the subscription, and the statement that some or all of the shares are without par value, if applicable. And letter I, if it a non-stock corporation, the amount of its capital, the name, nationalities, and residence addresses of the contributors, and the amount contributed by each. And lastly, letter J, such other matters consistent with law, which the incorporators may deem necessary and convenient. For our section 14, I know, ano pa pala? Pursuant to Section 181, which is the arbitration agreement, states that a dispute shall be non-arbitrable when it involves criminal offenses and interests of third parties. The arbitration agreement shall be binding on the corporation, its directors, trustees, officers, and executives or managers. So what is arbitration agreement nga ba? It is typically a clause in a broader contract in which you agree to settle out of court through arbitration cases in any dispute that arise with your counterpart. So, for our last section, for the last section of my report, section 14. Section 14, or form of articles of incorporation, it means that unless otherwise prescribed by special law, the articles of incorporation of all domestic corporations shall comply substantially with the following form. And these are the forms of the contents of section 13. Articles of incorporation, clauses 1 to 4. For the first clause, that the name of the said corporation shall be blank, Inc. or Incorporated Corporation or OPC. Second, that the purpose or purposes for which such corporation is incorporated, if there is more than one purpose, indicate primary and secondary purposes. Third, that the principal office of the corporation is located in the city, municipality of blank, province of blank, Philippines. Fourth, that the corporation shall have perpetual existence or a term of blank years from the date of issuance of certificate of incorporation. Clauses 5 and 6, which are the names, nationalities of the incorporators, and the names, nationalities, and residence of the trustees or the directors. Clauses 7 and 8, which is the authorized capital stock of the corporation, and for the 8, the number of shares of authorized capital stock above stated has been subscribed. For our clause 9, that the blank or elected subscribers as treasurer of the corporation will be wrote in here. Clauses 10 and 11 incorporate that the incorporators undertake to change the name of the corporation, or on this 10th clause, it is on the change in the name of the corporation. And for the 11th, it is the corporation which will engage in any business or activity reserved for Filipino citizens shall provide the following: no transfers of stocks or interest which shall reduce the ownership of Filipino citizens to less than the required percentage of capital stock as provided by existing laws shall be allowed or permitted by the record to be recorded in the proper books of the corporation, and this restriction shall be indicated of all stock certificate issued by the corporation. And for the continuation of the clause 11, in witness whereof we have hereunto signed these articles of corporation, the name and signature of the incorporators and the name and signature of the elected treasurer. So here they are. Articles of corporation example. I prepared an example that I fill out the forms of articles of incorporation, and here they are. Clauses 1 to 4 as an example. BUENVIAJE Incorporated in Steels. BUENVIAJE Steels Incorporated. Articles of Corporation of BUENVIAJE Steels Incorporated. First, that the name of the corporation shall be BUENVIAJE Steels Incorporated Corporation or OPC. Second, that the purpose which such corporation is incorporated is to conduct a lawful, ethical, profitable, and sustainable business in order to create value over the long term, which requires consideration of the stakeholders that are critical to its success, as determined by the corporation and the board of directors using its business judgment and with regular engagement with shareholders who are essential partners in supporting the corporation's pursuit of this mission. Third, that the principal office of the corporation is located in the city municipality of Antipolo, province of Rizal, Philippines. Fourth, that the corporation shall have perpetual existence or a term of 50 years from the date of issuance of certificate of incorporation. Clauses 5 and 6. The names, nationalities, and residence of our incorporators: Marla Articulo, Diane Martinez, Brian Bonifacio, Jessica Fortaleza, and Mayra Azcuna. 6. The number of directors or trustees of a corporation shall be 5. I only put 5 directors or trustees of a corporation as an example. The names, nationalities, and residence in here. And they are Jana Olmeda, Eliza Casha, Angelo Barak, Joy Ellen Estrada, and Ira Lubusayo. Clauses 7 and 8. 7th, the authorized capital stock of the corporation is 100,000 pesos divided into 25% shares with a par value of 25,000 pesos per share. In case all the shares are without par value, that the capital stock of the corporation is 75% shares without par value. That the capital stock of said corporation consists of 100% shares, of which 25% shares have a par value of 25,000 pesos, and of that 25,000 pesos each, and of which 75% shares are without par value. 8. That the number of shares of the authorized capital stock above stated has been subscribed as follows. I put only two names in here. The first one is Jacobo Herrera and second one is Sara de Hocos. For nationality, Philip both or Filipinos. Number of shares subscribed both is 25%. Amount subscribed 100,000 and amount paid are both 100,000. Clause 9. That Princess Ariane Gillies has been elected by the subscribers as treasurer of the corporation to act as such until after the successors were elected and qualified in accordance with the bylaws, that a treasurer authority has been given to receive in the name of for the benefit of the corporation all subscription contributions and donations paid given by the subscribers or members who certifies that the information set forth in the 7th and 8th clauses above, and that the paid up portion of the subscription in cash and or property for the benefit and credit of the corporation has been duly received. Clause 10 and 11. Same, that the incorporation undertake to change the name of the corporation immediately upon receipt of the notice from the commission that another corporation, partnership, or person has acquired. We'll discuss it later. And for our 11, the corporation will engage in business, no transfers of stocks or interest which will reduce the ownership of Filipino citizens to less than required for capital stock, and so on. For the continuation of the clause 11, and witness for all, we have here to sign these articles of corporation this 10th day of July 2020 in the city municipality of Antipolo, province of Rizal, Republic of the Philippines. Names and signatures of the incorporators: Marla Articulo, Diane Martinez, Brian Bonifacio, Jessica Fortaleza, and Mara Azcuna. And the name and signature of treasurer of the corporation will be Princess Ariane Vigilias. Subscription and paid up capital. Subscription. A subscription is a written contract to purchase newly issued shares of stock or bonds. It is also termed as stock subscription. A subscription is a agreement functions in much the same way or as a standard purchase agreement. On one side, it is a promise by a private company to sell a specific number of shares at a specified price to a private sector, also called subscribers. Paid up capital. Paid up capital is the portion of the authorized capital stock which has been both subscribed and paid. To reiterate, such must form part of the authorized capital stock of the corporation, subscribed and then actually paid. The keyword for this will be subscribed and actually paid. Articles of Incorporation. Articles of Incorporation. It means that the Articles of Incorporation has been described as one that defines the character of the corporation and the contractual relationship between the state and the corporation, the stakeholders, stockholders, and the state, and between the corporation and its stockholders. There is no gainsaying that the contents of the articles of corporation are binding not only the corporation but also on its shareholders. It is also referred to as a certificate of incorporation or the corporate character as a document that establishes the existence of the corporation in the Philippines. Since a corporation is a juridical or artificial person created by law, it should be registered with the Security of Exchange Commission or SECT in the Philippines. So for the threefold nature of the articles of incorporation, first one is the contract between the state and the corporation. Second one is the contract between the corporation and its stockholders, and the contract between the stockholders and intrae. Intrae is the Latin or legal Latin phrase that means among or between themselves. It is used to distinguish the rights or duties between two or more parties from their rights, duties to others. Name of the corporation. The name of the corporation is peculiarly important as necessary to the very existence of the corporation. Its name is one of the attributes and elements of its existence and essential to its identity. The general rule as to corporation is that each corporation must have a name by which it is sue and be sued and do all legal acts. The name of the corporation in this respect designates the corporation in the same manner as the name of an individual designates the person, and the right to use its corporate name is as much as the corporation franchises any other privilege granted. It simply means that your corporate name is the legal name of your corporation. This name identifies your corporation and you must use it in all contracts and invoices. So, for the next one of the name of the corporation is the limitations on the use of the corporate name. The name must not be identical, deceptively or confusingly similar that of an existence corporation or to other name already protected by law, or patently deceptive, confusing, or contrary to law. It must contain the word inc dot corporation or OPC. As you can see on the form of the Articles of Incorporation, it is indicated there that it has incorporated corporation or OPC on the first clause of the form of the Articles of the Incorporation. And what is that OPC? OPC or one person corporation, it is owned by a single stockholder. Since it is or it will discussed by Ms. Bandebas, I will not discuss it further. Next is the change or of corporate name. A corporation can change its name by amending its articles of incorporation on the 10th form or contents or clause of the articles of incorporation. For a change of a corporate name, the business entity must submit to the Security of Exchange Commission or SECT a name verification slip and affidavit of a director, trustee, or officer agreeing to said change. The affidavit is not required if it has previously been stated in the Articles of Incorporation. The Security of Exchange Commission, or commonly known as SEC, in turn will issue an amended certificate of incorporation using the name upon approval, as stated in Section 18 of the Corporation Code of the Philippines. Next is the purpose clause. For the purpose clause, this will confer as well as limits the power which a corporation may exercise. Any act beyond its powers is known as ultra vires acts. Where a corporation has more than one stated purpose, the articles of incorporation shall state which is the primary purpose and which is or the secondary purpose or purposes to determine which investment to corporate funds requires the authority of both the board and stockholders. Ultra-Vires Act, it means or translates to beyond the powers. It is used to describe an act which requires a legal authority or power but is then completed outside or without the requisite authority. The next one is the principal office of the corporation. There are four purposes, and these are: first, to fix the residence of the indefinite in a definite place. Second, to determine the venue of court cases involving the corporation. Third, for purposes of stockholders or members meeting. And fourth, to determine the place where the books and records of the corporation are ordinarily kept. You can see this one on the third clause or third content of the form of the articles of incorporation. Next one is the term of existence, number of board or trustees, and authorized capital stocks. The first one will be the term of existence. A corporation shall have a perpetual existence unless its articles of incorporation provides otherwise. Under the old corporation code, the maximum corporation term is only 50 years. Subject to extensions, the limit on corporation term has been removed. Second one is the number of board of directors or trustees. The number of board of directors shall not be more than 15. The number of trustees may be more than 15. Typically, the corporation must have at least 9 directors in order to classify the board. In a classified board of directors, the shareholder elects either one half or 1/3 of the directors at each annual shareholders meeting. Each director then serves a 2 or 3 year term. As an example, the board of directors of San Miguel Corporation has 15. Mr. Eduardo M. Cuanco Jr. up to Mr. Margarito B. Teves. Mr. Eduardo M. Cuanco, who is the chairman and CEO of the San Miguel Corporation, and Mr. Margarito B. Teves, who's independent director. The last one will be the authorized capital stock. Authorized capital stock, this is the maximum amount fixed in the articles of incorporation that may be subscribed and paid by the stockholders of the corporation. The number of authorized shares or stocks is initially set in the company's articles of incorporation and can be increased thereafter if a majority of the shareholders approve of the change. The number of authorized shares is relatively high, and it is disclosed in the company's financial statement. In the Philippines, the authorized capital stock is at least 25%, must be subscribed, and must be paid at the time of incorporation. The authorized capital stock of the corporation, you can see it in the seventh clause or contents on the forms to Article Corporation, and the subscribers is on the 8th clause or contents of the Articles of Incorporation. And that's all for these sections 12, 13, 14 of the Governing Law Republic Act number 11232, the Revised Corporation Code of the Philippines. Again, I am Jessamine Biaje. Thank you for listening.